Today's live session is really, oh, I forgot to say hi to all the friends on TikTok, all the friends on Instagram, Red, and we're going to post this on YouTube, this whole video series, like what we do every single week. The first half is going to be on a very important news update, generally things that you do not find online. And what we're doing is we're going to be talking about the newest CBP posting on May 1st, 2025 regarding what happens when a green card holder re-enters the US. That is going to be the main thing we're diving into today. But at the same time, I want to do a public response to the video we posted a few days ago. 3 green card holders were denied and they could not enter the United States. That was the video where I was coming back from Mexico. I was talking about my disappointment because 3 green card holders and their families could not come back. And I was explaining the process, the disappointment, and we got a lot of responses and comments, and some of them are very heartfelt, and I feel like I really need to clarify a lot of things about my profession, about what we're doing, and I hope that will be good. So let's directly jump into the news segment for today. Customs Border Patrol announced this new policy on May 1st on their website. There's been very little responses and there's been very little update on this, but it is quite alarming. The reason why is because if you look into that middle part, they said they have a new inspection policy. But what is that new inspection policy? That is their internal record on how they process things. Typically, when customs are enforcing anything new, if USCIS is enforcing anything new, if ICE is enforcing anything new, if any government agency is going to enforce anything new that will have a significant impact on the rights and privileges and duties of the residents and with the rest of the world, typically there's a public comment, there's a lot of things that is open. But right now, it is a little opaque. So next week, I'm going to LAX to go see some of the CBP officers. And we're gonna sit down and we're gonna really dive into it. There's about 15 attorneys that are gonna go together, and we do this on a quarterly, but this is a very timely event where they updated the website. And this website update is actually CBP national, so it's not just LAX, but LAX definitely should have some guidance on what this new inspection is. So I'm gonna find out a lot more information next week, and then we're gonna report it next Thursday. But right now, I just wanna kind of explain the overall idea, and this will tie into what happened a few days ago when we were driving back and the green card holders that were stuck overseas. Okay, so here is the big background. The CBP website essentially pulled out one section of USC Code 1101 stating if a green card holder left the United States for a continuous period of over 180 days, basically 6 months, they will be inspected and they will be considered seeking admission. That is really important. Now, why is that so important? Because the background to this is that Congress enacted this law saying green card holders, when they are entering the United States, they are not seeking admission unless these exceptions apply. So generally speaking, CBP officers are not supposed to be inspecting lawful permanent residents for the purposes of them seeking admission. That is a very technical phrase. Prior to Congress enacting this law, it wasn't that way. Every single time a green card holder was coming to the United States, they're seeking admission. CBP has wide latitude of discretionary authority to potentially deny them entry, to confiscate their green card, to do all sorts of things prior to this, this congressional act. So now it's saying, okay, if the green card holder has officially abandoned the green card, then they might be seeking admission. If they have committed crime of moral turpitude, they are seeking admission. If they've left the United States for over 100 days, they're seeking admission, right? So there's certain categories where now, as a green card holder, when you're coming back in, you were protected under congressional law. You're not seeking admission, but now you are. And if you fall into that category, again, CBP has a wide latitude of authority to decide whether or not you're seeking admission. And that is so important because for green card holders, you're almost downgraded a step, right? Before you have the protections and privileges of a lawful permanent resident, if you're seeking admission, it's almost as if you're not a green card holder. That is a pretty big deal. Again, Congress didn't change any laws. This was and has been the law for many decades now. But what's new is that now CBP has pulled out this section about the 180 days and have posted it and said now there's new immigration inspection policies and priorities for green card holders who are entering in. What is that? What does it look like? We'll find out next week. Now, there are many people who are green card holders who live overseas for many different reasons. And in the past 4 or 5 years, actually way before that, right? Ever since like 2016, 2015, we've been working with CBP officers and we've been working with clients to try to come back if they've left the US for over a year, for over 2 years. The reason why I was so disappointed a few days ago and when I was filming that in the car was because in the past 4 or 5 years, there have been many people who've been out of the United States for over 1 year who have very sympathetic reasons. And when I was reading through the comments, I completely understand. If you're just looking at this as if it's a math problem, you left for over 180 days, you left for over 1 year, you're considered abandoned. That's what the law says. And that is frankly not entirely true, okay? The wisdom of Congress has empowered the CBP officers to make these discretionary calls because life happens. And if somebody is just out of the US for a certain period of time and you suddenly deem their green card abandoned, that is a very severe punishment. And if you make it such a clear red line policy like this, it looks bad on America, it looks bad on the justice system. So they empower CBP officers, customs officers, to review each application. If you're out for 188 days, sure, we'll question you. If you're out for 1 year, prove to me that you did not abandon. And in the past 4 or 5 years, you can see there was COVID, airlines were shut down, people got sick. There have been a lot of sympathetic situations that happen on a case-by-case basis and for CBP officers to adjudicate. In the past 4 or 5 years, we've done so many cases and we have seen officers, good officers, across the United States at different airports, JFK, LAX, San Francisco, Seattle, Houston, as well as Mexico and Canada, who've done their job in reviewing so many different situations. Now, again, a lot of these comments, when they're looking through, and there's like, you've been out for 5 years, for 8 years, you've abandoned the United States, you don't deserve your green card. I feel like that's fair when you're just, if the only information you know is that they've been out for so long, then the officers didn't do anything wrong. And I'm not saying the officers did anything wrong. My disappointment was not in the CBP officer. I hope that's clear. My disappointment is that the week before last week, we were just able to help many other people come into the United States who've left for over 5 years and 8 years. And the only difference was that one of the clients, this time, they had an arrest that was dropped. The case was dropped, but they just merely had an arrest. And just because of that small difference, now the CBP officer is saying, I cannot adjudicate this case and let them in without contacting ICE and having ICE potentially come and detain them. That was the key difference. Okay, so the CBP officer is not saying, I will not let them in. It's saying, if they come, because of this, it triggers something in the system that and I have to contact ICE, and then your clients have to be prepared to be detained. And that is the disappointing news for an arrest that was dropped, right? If it was a conviction, if it was a felony, if there was a warrant, totally understand. But my disappointment is in the fact that the CBP officer's hands were tied, right? I'm trying to respect the CBP officer, but because their hands are tied, because of the current policy in the United States with regarding the zero tolerance rule. Now, these folks cannot come back. Now, you might be saying, but out for 5 years, out for 8 years, that's ridiculous. Let me provide some additional information, and then you can be the judge of that. I just want to provide a little bit more context to the people who left the United States for over 180 days and why CBP officers, in all of their wisdom and judgment, have allowed different people to come in, even though they left for over 180 days, over a year. There was a client who was in a car accident and bedridden for 9 years. They couldn't get out of the hospital. Should that person be considered to have abandoned their green card? It was beyond their control, right? You could decide, but I'm just letting you know, when I talked to the officer and when I brought the client and when the doctor accompanied them to see the officer decided to let them in. You could think that he shouldn't, but that's what he did. There was several other cases. They left the United States for over 5 years, 8 years, but they left when they were a child, 6, 7, 8 years old. Their parents took them away. But now they want to come back. Should the decisions of the parents impact the kids? They went to international schools, they got good grades, they're accepted to an elite Ivy League university in the United States. They've been filing taxes the entire time, a lot of taxes, by the way. And so now they want to come back in and now pursue their own individual career. Should they be allowed the green card? Other people who've left the United States, their fathers passed away, their mother passed away, and they had to arrange for funeral situations during COVID, so they were out for 4 years. What if they were out and they had a reentry permit, but because of COVID, they couldn't come back, and then somebody passes away and they had to take care of them, their spouse, for example, and they left the United States for 4 or 5 years. These are all cases that are real, that we've done videos on over and over again in the past 4 years. And what we do is we take the situation that they're in. I drive down to Mexico. I present it before the officer, and I say, will you give this person an interview? Will you adjudicate them based on their circumstances? They have valid green cards. Some of them just expired, but they have a renewal. Here's an I-90 receipt. Here's a person who's been outside of the U.S. for 13 years, but they were sent abroad by a Fortune 500 company, and they're a director of this Fortune 500 company, and they were working on project after project, and now they're finally coming back. The HR team of the company is on standby if you're willing to talk to them. I did all of these different cases, and the officer reviewed it and said, yes, they're permitted to come back in. So I totally understand if it's a few years ago, when I hear, oh, somebody's coming back in, trying to come back in, if they left the US for 2 years or 3 years, that's crazy hard. I get it, because I was there. But after doing a case where somebody's been outside for 4 years and I see the officers are understanding, we did another case out of the US for 8 years. 10 years, 13 years. And we've been continuously doing that, and seeing the officers adjudicate these cases with such grace and understanding makes me love the United States immigration system. When the consulates reject the SB1 visas, because it's essentially granting a brand new visa, CBP officers have the discretion to allow people in and basically save their green card. When USCIS are denying cases, the CBP officers can allow different people in. And so I'm not bending the law. There was a comment where it's like, it seems like I'm like advocating or twisting law. I'm not, right? As lawyers, what we do is we take the facts of the clients, we prepare well, and we do our best to make the argument. Did they abandon their residency? Did they really, truly abandon their intent to come back to the United States? Was their trip abroad temporary in nature, whether it's 1 year or 5 years or 8 years? Well, we have the documents to prove they've been paying taxes, they have a home, they want to go back to school, they have a social security, they have a retirement, they are trustee of a trust, their inheritance, their immediate relatives passed away overseas, their U.S. citizen spouse is right next to them, their children are, we did a case for a grandma where like the entire village basically came with them to come back to the U.S. because everybody else is a U.S. citizen, but the grandma was stuck abroad. Officers saw that, allowed them in, and everybody embraced, So if you think that's wrong, If you think CBP officers should not do that and should just be a very straight line, out for 180 days, sorry, deny entry, you cannot come back. Out for a year, confiscate green card, you're gonna go through detention and be locked up for 30 days. You know, that might be the way of the future. That might be what CBP is doing. We don't know. I will find out next week. But at least in the past 4 or 5 years, that's what we have been doing. And we have seen tremendous success for these clients, and I'm really, really happy for them. But now circumstances have changed. There's a new president, there's a new boss in town, there's a new executive order, there's zero tolerance. We're in a state of war because of invasion. So CBP's officers' hands are tied. They no longer have the authority that they used to have. We're not talking about illegal immigrants trying to enter the country, by the way. We're not talking about people who are trying to smuggle, you know, fentanyl into the United States. We're talking about people with a very sympathetic reason, who are green card holders, who are spouses, children, parents of US citizens, not being able to come in. And if they come in, they have to be arrested and detained for 30, 40 days, right? That is what I'm talking about. And CBP's officers' hands are tied in many of these situations. And the newest update on the CBP website as of May 1st, 2025, is that if you've left the United States for over 180 days, there's a new inspection procedure because these people are seeking admission. What does that look like? We don't know. There could be a lot of things. But for people who have not returned yet, I implore you to come back as soon as possible, because in the past 3-4 months, I could see the trend is getting much more strict and potentially even stricter than pre-COVID. And if you don't have a reentry permit, this is a time that you really have to prepare. Talk about why the US is your home and you did not abandon it, and talk about why you had to leave for a temporary measure.
Do you want to talk like specifically about some of the comments we got on our last video or no?
Sure. No, I have some printed out here. This question was, who pays my salary, right? This is an NGO. We are a private law firm here in California. We have offices in Hainan, Shanghai, and in Taipei. We've been here for 30 years. And our service has evolved over the years in many different ways. For LPR, for green card holders who are overseas trying to come back, right? We try to help most people by just doing a consultation or releasing informative and good videos like this. And you can look on our playlist, there's a lot. We try to provide the information, the know-how, and the response, because a lot of people are just misinformed, right? For example, they might think, all I have to do is file my taxes and I deserve to be in the US and I already have my green card. They don't know about not being able to leave for a significant amount of time. Maybe their prior attorney didn't tell them, maybe just didn't know. Obviously, ignorance is not an excuse, but because they didn't know, now they've been out for a year, 2 years, or 3 years, then they find us, then we're saying, well, now you do know, this is what you need to prepare for, right? And we're trying to educate people on all the different options, right? You might be able to apply for I-193 waiver. You might be able to go and speak to a supervisor at deferred inspection, right? Different things to educate the client, and talking about the consequences of signing a 407. Maybe the client doesn't speak English that well, and so maybe when the officer presents them with the 407, they thought, oh, I'm able to come in now. So they sign it, and inadvertently, they abandon their green card. And that has drastic consequences, right? So that's what we do a lot. And for certain cases, the most difficult ones, the most difficult ones, if you're out of the US for over 2 years, 3 years, if you have a criminal record, if you've been warned before, if you don't have a reentry permit, if you lost your green card, those are the cases where I take everything and I go speak to officers and say, can you let this person in, right? Would you give them an interview to present themselves? And if they don't do pre-clearance, but they say, all right, I understand, provide these documents, bring them, and then we'll talk to them. Then I go and pick up the client, I go with them to go see the officer, right? That's for the most difficult cases, the ones that have been out for like 8 years, 9 years, 13 years, but they have a sympathetic story, right? If they didn't, they wouldn't want to come back. And if they didn't, they wouldn't go through all this hassle in trying to come back, right? All right, cool. You got a question?
What if you lied on a bank form about being a citizen, was approved for a green card, and then applied for U.S. citizenship?
If there's any way USCIS finds out, or a CBP officer finds out, that you've had claimed to be a U.S. citizen, even if it's like a lemonade stand, right? That is a permanent bar, and that can cause your green card to be revoked. I kid you not. So be very, very careful when you go through these immigration proceedings.
Okay. No other questions for now?
Okay, that was a heavy one.
Yeah.
Let me see, what other...
When clients have like a low probability of success,
Right.
they say, are you just driving down there to collect a paycheck? Do you why offer this service to people with no hope?
That's a great question.
Follow up
Oh.
before that.
No.
Even if you disclosed the lying on the form, they say, even if you disclosed it.
Yep. Even if you disclosed it, if one officer didn't catch it, the next officer could catch it and terminate your green card. Arguably, they could even terminate your citizenship. Meaning, let's say you successfully became a citizen, they can go back and revoke it, right? That is a trend that we're going to see happen more and more. That is for sure. They've been starting this policy of trying to revoke people's citizenship ever since the Obama era, investigating. So it is a risk that will almost forever be there.
What if they disclose it on the green card form?
Like I said, right? It is a permanent bar, so it potentially was just not caught, right?
Would they go through your credit to look at your card agreements?
If you're asking whether or not USCIS, in adjudicating your citizenship, or even green card application, would request you to provide your credit card statements / mortgage statement / application, the answer I can give from my personal experience and this firm's experience is no. I have never seen an officer request those type of evidence. Should they? Should they not? I don't know. But that I haven't seen them do that. And to the best of my knowledge, credit card companies, and they do not share this information with the United States government for immigration purposes.
Yeah, that we know of.
That we know of.
Mm-hmm. Yeah. But yeah, I think that comment, why sell this service to people with no hope, is so interesting because
yeah,
this was one of the first times where the client actually flew down to Mexico and got turned away. Is that correct?
Right.
So I just think that's it's interesting. But yeah, how would you respond to that?
Yeah. This has never been made public before. Out of all the services that we do, we don't have a refund policy because we work really hard and we try our best to elevate the client's case, right? We cannot guarantee any outcomes, so we don't have a refund policy. Very few firms do, some do, but I shy away from those type of business models. Yet, in the 30 years that we do this, and out of all the service that we do, the one type of case that we do offer the full refund policy is when the clients go through all this hardship and all this headache and all this trial to try to re-enter the US. They fly to Mexico. We go down to Mexico multiple times. We talk to officer, we liaison, we prepare them, and we pick them up and we try to enter. And if it was not successful, like the case last week, we do a full refund policy. And we're not here because think about the litigation aspect of that, right? The client is trusting us. We're trusting the government. There's so much trust going around. If it doesn't work, I'm not going to drag the government. I'm not going to, it's just, you know what? It's just a full refund back to the client. They've already suffered enough emotionally to go through this process. And so, for people who are saying, wow, you are just charging people when there is no hope. If there was no hope, would I really want to sacrifice like entire weeks to go down, right? It takes hours for me to drive down. I wake up at 5 o'clock in the morning. I go talk to these officers, and I wouldn't want to waste my time. The second thing is, we have over 500 success cases in the past 5 years, right? I've been to Mexico over 250 times, helping different people with very difficult cases succeed. This is the first time it didn't work. And it's, again, I don't want to go through why it didn't work. We already said it in the video. And to the last, reason, why charge people when you feel like there's absolutely no hope? Hope is believing in nearly the impossible, the unseen. And so much of success and success stories once started as that faith. You don't know if you're going to get approved for the green card, but you tried and you got approved. You had to leave and you had an urgent reason and you were stuck abroad and you wanted to come back. There's no hope. There's no chance. There's high chance you might get denied, but you believed your story will be heard. We tried and it succeeds, right? So I don't want to be the judge and prosecutor for the client's fate. The client has the faith that they want to try. I provide the pathway. This is how we do it. We cannot guarantee, but the clients entrust us. We do our best to make it happen. And for the cases that succeed, everybody wins, everybody's happy. The United States is better for it because it looked good. If it fails, it's really hard, but at least we had that full refund policy for these type of clients. But that we only provide that full refund for these type of services. For everything else, right? Investment, EB5 visas, E2s, EB1As, our job is to just do our absolute best to try to help the client win.